Hello friends, welcome to my channel. This is CA Neelam Ashok, your friend, and this is the fourth video of my series on the charge creation, all about creation of charges under Companies Act. Right? In the first video, we had seen about the creation of charges, its definition as per Transfer of Properties Act, as per Companies Act. Then we saw about mortgage and the difference between charge and mortgage, then mortgage by deposit of title deeds. We saw about the principal rule of creation of charge, that charge will be created only on the assets of the company, assets as defined in schedule 3 of Companies Act 2013. Then we pondered about the FAQs, the most common questions, whether the charge will be created on the hypothecation of vehicles, whether charge will be created on the pledge, and then the third question was whether there is need to create a charge on the personal guarantee of the promoters. The fourth point that we saw was corporate guarantee and mortgage of the property. The fifth was whether guarantee given by the company to other company amounts to creation of charge. Next, we saw whether charge will be created on the FDR of the company. The seventh point that we saw was whether charge can be created on future assets of the company, and the time limit for CHG1 in case of assets outside India. Then we also saw about the charge creation in case of modification. And now in this video we will see the remaining points. Friends, I would like to clarify once again, these videos have been prepared on the basis of my personal experiences which I have faced in so many years of my practice, and of course I have referred to Companies Act and other provisions also, and the Transfer of Properties Act, but the crux of it is has been formed out of my own personal experience. You please may refer it as for an educational purpose, but in case of any issue, use your own mind, use your own knowledge also, refer Companies Act yourself also. Please, this is only for educational purpose only. Okay. Right, now in this video we will see whether charge will be created on hire purchase agreement. A hire purchase agreement places the financier in the position of a secured creditor. So a hire purchase agreement must be registered as a charge. There is also a case law, official liquidator Manasuba and Company Private Limited versus Commissioner of Police 1968. Next question is, from which date the charge is considered as registered? Uh, we can say this is a very common question also, as there now we have three dates. One date is the date of the document. Second date is date when the charge is registered at ROC. And the third is the date when the form CHG1 is filed at MCA. Right? We have three dates. Now the confusion is from which date we can say that the charge is registered. Okay. In It was held in the case of SBI versus Haryana Rubber Industries 1986 that the charge stands registered from the date of filing of particulars even if the ROC delays making entries in his books. Okay. Moreover, it was held that in case of official liquidator versus Union Bank of India, that non-compliance does not mean that the transaction is void or debt is not recoverable. Only consequence is that the security becomes void against liquidator and creditors. So, in case of non-registration of charge, you will stand as an unsecured creditor. You will not come in the secured creditor list. And the date on which the document is filed at ROC will be the date from which we can consider that the charge has been registered. The today you see, today nowadays the day you file the charge, the same date the charge gets registered. There is a very less issue. And but in earlier days the registrar of companies took 3 or 4 days for registering of a charge, and in case of any discrepancy it might have taken longer. So the date as per this act we see is the date of filing of document of the of Form CG1 at the MCA is considered as the date of registration, uh, date of registration, and the list of secured creditors by an official liquidator is taken from the date of filing of Form CG1. Okay. Now the next question is, in case the company fails to register the charge. Just now we saw this case law also, that in case the company fails to fails to register the charge according to section 77 of the Companies Act, all types of charges created by the company are to be registered by the ROC. Where they are non-compliant and they are not filed with the registrar of companies for registration, it shall be void against the liquidator and any other creditor of the company. Okay. Now the next 13th question is whether register of charges can be maintained at any place other than registered office of the company. As per Rule 10.1, the register shall be kept at the registered office of the company. Company cannot maintain the register of charges at any other place. Okay. And who can authenticate the entry in the register of charges? The entries in register of charges shall be authenticated by the director or the secretary of the company or any other person authorized by board for this purpose. And who can inspect the register of charges? Any member or creditor of the company without fees. Any other person for payment of fees can register the charges of the register of charges of the company. Now one more question in the recent time has come over, whether provision of charge will be applicable to one person company. The provisions of this chapter shall apply mutatis mutandis to one person company also. All the provisions of filing of charges will apply to one person company also. Okay friends, I hope a number of points may have been clarified to you with my videos. Thank you so much for watching, and please do subscribe. It not only gives an immense boost to post such videos and share my knowledge with you, and also it gives a great pleasure. Thank you friends.